What's up, guys? Darrell Brooks again. He represented himself and he kept giving the judge such a hard time just when she was using a baseball analogy trying to explain to him her role in the case. Hey guys, Colton Richardson here, personal injury attorney and former prosecutor, and this is another episode of where Darrell Brooks is just going crazy. So let's jump right in and watch it.
You're saying it goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
Okay, well, I don't know how you want me to answer
How
that.
would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so it do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I would recall the witness if I determined.
I'm well aware what an offer of proof is.
Okay,
I'm well aware.
so make your offer of proof.
I don't need to. It's
Because he doesn't know what to say.
clear. It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument. You're telling me that it's clear.
I wasn't referring that to you. The person that it was referred to know who they are.
Well, let's stay on task, please. So
I'm trying to.
You're claiming it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask.
Mr. Brooks,
but then when I
had an objection before. Well, here's the thing. You want to go off target and you want to bring up things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear, that I object quite often, and every single time I object is just thrown to the side.
Probably because they're bad objections, maybe. I don't know.
Every single time.
Well, I would disagree with that characterization, sir.
And I make
my rulings in this
why
case
would you disagree with that?
I'm like an
Point out one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them. That is my role, and that is what I do. And
are you kidding me?
Are you kidding me?
That's exactly what I do. I'm an umpire, sir. I am a referee in this trial.
If you're the umpire,
which is exactly right. I mean, the judge is the umpire of the court. There's two different sides fighting for their positions, their clients, and she makes rulings on objections, on evidence, on what comes in, what stays out. And so it really is a referee. And even that's something that I've been asked is, do I want to be a judge? I do not want to be a judge. And my response to when I get asked that is, I'd rather be playing the game than the referee. Although I respect all the judges, I feel like I'm better suited to play the game.
Let me finish.
Okay.
Let me finish,
okay.
Mr. Brooks.
I apologize. I'm letting you finish.
Sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections, I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the statutes, which once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine.
But she doesn't have to give him the rules of evidence.
But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance of the law is not a defense for any of us. Okay? And you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I've asked you repeatedly for an offer of proof You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break, and when we come back on, the state should be prepared to call the next witness.
Can I release at least rebuttal to what you just said, since you asked me not to?
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not about agreeing. You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record.
He's got a point.
What would you like to put on the record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
now you
whether
said
the
that.
state's
I
doing
didn't
other
even bring
things.
that
I'm
up, Your Honor.
only asking you to address the offer of proof.
No,
if
I
you
wanna-
have something, go ahead. But only as it relates to
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting... Okay, go ahead, sir. I'm not sure why you need to respond to that.
Yeah, she's just trying to give him an analogy so he can better wrap his head around her position in the case.
Because it needs to be on the record. If you're the umpire, that means you're the referee.
Very good.
That's what I'm doing here today, sir.
And you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't question
make it
anybody
so.
about that.
Okay?
That was between you and I. That didn't have nothing to do with a witness. I've
You
never
want to
once
question
questioned a
these
witness
witnesses,
about subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I am not going to explain that because I don't have to explain that.
What's my reason for asking it?
Well, I believe you've made it very clear, sir. So here's the bottom line.
I don't.
One of my roles is to be the umpire.
Then you got to be
right?
fair, Your Honor. You're a public servant.
I am fair, and I'm
No,
going
you're
to follow
not.
the
You're not
rules
being
of
fair.
evidence.
Your
sir.
Honor,
that
this is
doesn't
why I
mean
say that.
unfettered questioning
This is
of
why I say that.
witnesses that are not relevant or that call for hearsay or for a variety of other reasons that are speculative. There's a whole host of reasons in the rules of evidence, sir, that require me to make those determinations.
You're not being fair.
I respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree with the characterization. I think it has more to do with your lack of understanding of the rules of evidence and the rules of procedure, which you knowingly and freely and voluntarily and deliberately made a choice to represent yourself. And
you keep saying that because it sounds good on the record, but it's not accurate. You accepted when you gave me the paperwork, Your Honor. I gave it back to you.
I'm not going in. I didn't say that, sir, so we can go back and rehash all of those things.
But you know you accepted the way that I gave you the paperwork back. So once you accept
I made findings on the record, which I will stand by, sir. So
I'm not
we're going to take...
And he keeps going on different tangents, trying to go from one argument to the next to different issues. It's crazy. That's crazy. So Darrell Brooks was saying that the judge is not being fair, and the judge's role is like an umpire, and even though she's an umpire, she's still not being fair. But really, the judge just says, you don't know the rules of evidence, and you should look at the rules of evidence because I actually gave them to you. So that was crazy, and if you like this video, check out this next one about Darrell Brooks as well.